Welcome everyone to the first topic lecture for the criminal justice reform topic at the DDI. I think I would like to start by just saying and underscoring how important this year's topic is. It is an issue of national immediate relevance that how our criminal justice system works. There are waves of national and even international protests regarding police brutality in the United States, but that's not even, that's only the tip of the iceberg compared to kind of a history of movements and activism and public debate about what the purpose of our criminal justice system should be, how we should reform it, and how we should address its worst excesses. So I think that it is not only timely, but also incredibly important that we all debate this topic. And I'm excited to see how debaters use what they learn on this topic in order to improve the world. An interesting fact is that the person who recorded George Floyd's murder, which sparked a whole bunch of these protests, was actually a teenager, like many of you. And that kind of goes to show how an outsized and large influence young people can have on our democracy and on the public's stance on criminal justice reform and the system. So I'm excited to talk about that with you all today. I'm going to try to allow a little bit of time for questions at the end of each section of this, as well as a decent amount of time at the end so that we can use the Q&A function and hopefully answer all of your questions. I obviously have to add a disclaimer that none of this substitutes for or counts as legal advice. If you're actually in legal trouble, don't listen to what a debater tells you about the law, talk to a lawyer. But without further ado, section 1, which is generally criminal justice reform, which is the first part of the resolution. I want to start by addressing the purpose of the criminal justice system, which broadly is our society's response to criminal acts. And that begs the question, of course, what is a crime? And while it might seem a little bit obvious, it's actually kind of a technical term and composed of 3 necessary components that are involved in every single crime. The first is what's called actus rectus, which is a Latin term for essentially the action component of a crime. And there's 2 different types of it. It can either be an action committed in violation of a law prohibiting it, which is a common, maybe the most common example of a crime action. So killing a person, stealing from a store. These are actions that are committed in violations of laws that prohibit doing those things. But also a crime's action or actus rectus can be an action omitted in violation of a law ordering it. And a good example of that are reporting laws, say mandatory reporters or reporters in the federal bureaucracy that have to, report wrongdoing in oversight roles, etc. So it can also be a crime to not fulfill a legal obligation when you maybe you should, or when a law requires it. The second component of a crime is what's called mens rea, or the mental state that a person has when they commit an action. And in our legal system, it is the intent to commit wrongdoing. And so that requires that when you do an action that previously described in actus rectus, that there is an intent to do harm by that action. And sometimes statutes will specifically say what the mens rea is. So, for example, for first-degree murder, you have to be premeditated in your desire to kill a person. And all of the various murder statutes actually lay out what is required mental state in order to convict a person of various degrees of murder. However, a lot of times the mens rea, or the mental state for an action to be considered a crime, is not specified by statute. And so courts defer to mens rea necessary to reasonably separate criminal from innocent conduct. And that is from the court case Alanis v. United States. Throughout this lecture, I'm going to reference a lot of different court cases and that establish the various concepts that I'm talking about. That won't come up too much, I bet, in your year of debate, but it does establish helpful context for understanding where a lot of these doctrines come from, and potentially place precedents that AFs can cite or counterplans can cite in order to advance your arguments on the topic. The third element of committing a crime is causation. And that means that it's a connection between the action that the person took and a result. So examples of results that constitute the third element of a crime are injury, death, stolen property, etc. And this means that, you can't just fire a gun into the air and someone standing right next to you dies. There has to be a connection between the action that you took and the result or that happened in order for it to constitute murder or you shooting a person. However, there are also what are called inchoate crimes, which are indirect. And those are the crimes of attempt, solicitation, and conspiracy, threat, possession, aiding and abetting, and accessory. And while these all seem like they don't have causation, for example, attempted murder may not seem like it has causation because no one actually ends up dying, they still do have causation because the result of those crimes is still some amount of harm. And so those are all indirect or inchoate crimes that we define as well. So all things that are policed, all things that have sentences for them, and all things that potentially have or require forensic science in order to prove. So all things that are potential arguments or places for affirmatives on this topic. All three of those elements must be proven by the government beyond a reasonable doubt in order to gain a conviction. And that's opposed to the other standard of preponderance of the evidence, which is actually a lesser standard that is used in civil, not criminal cases. All three of those elements also have to exist concurrently. So for example, if Mary accidentally runs over Tom, Tom sustains an injury, and then 2 years later, Mary and Tom have an argument that makes Mary want to kill Tom, that doesn't constitute a crime because all three of the elements necessary to make a crime do not happen concurrently. So that's kind of an introduction to what crimes are and what our criminal justice system is designed to address. I want to break down the topic STEM, which is criminal justice reform, into its two pieces, criminal justice and reform. The first, criminal justice, is a little bit easier to understand in terms of what it excludes. So almost immediately and obviously, it doesn't include any civil procedure or tort law. And the reason why those are different is that in a civil case, the government is often adjudicating a dispute between two people, or someone is suing the government, or the government is suing an individual. But in all of those cases, there can never be the prospect of jail time. Your liberty can never be suspended as a result of a civil case. There can only be some redistribution of property or other types of non-jail penalties that can be governed or mandated by the government. There's also military justice, which is outside the realm of criminal justice. International law and justice are not criminal justice, and largely immigration as well. Although there are some criminal aspects of immigration law, an overwhelming majority of immigration law is civil, and that's because the big body of statutes that govern immigration law, the Immigration and Nationality Act, or the INA, is primarily civil law that allows the government to take civil action against people who are not in the United States legally, and therefore it's civil. Criminal justice, though, does include tribal law, for example, and there's a really recent court case, McGirt v. Oklahoma, which actually ruled on this issue and said that crimes committed in tribal territory can be tried either by tribal or federal courts, but not state and local courts, which not only kind of explicitly categorizes crimes committed or offenses committed on tribal land as in the domain of criminal justice, but also delineates authority to prosecute or convict those crimes to only federal and tribal authorities. So states and locales don't have the authority to do that, which is potentially one area where acts that involve tribal crimes committed on tribal land may have a good state's counterplan answers because the states don't have authority to make criminal code or enforce statutes in those areas. Okay, and so largely criminal justice differs from a lot of other aspects of the United States judicial system in that it can assign suspension of liberty as a penalty or as a sentence. Reform, the other part of the topic STEM, is divided into roughly procedural and substantive reforms. And there's a lot of overlap between these, but it's generally a good way of thinking about it, which is where procedural reforms or the procedural aspects of the criminal justice system address criminal procedure or process. So they address how the laws, the Constitution, and the criminal code are enforced and enacted. They govern what things judges should be thinking about when they're assigning a sentence. They ensure that there's not disparate racial impacts in various aspects of the criminal justice system. They might govern what police officers are allowed to do when they have individuals in custody, because they guide how the statute should be enforced. This is compared to substantive reforms, or the substantive aspects of the criminal justice system, which is the criminal code and the criminal law itself, which is roughly a series of crimes and punishments that go with them that are then guided by the procedural aspect of the system in order to try, convict, and sentence people accused of crimes. I'll talk more about procedural and substantive reforms when I get to individual areas or aspects of the criminal justice system, because that hopefully I'll be able to give a lot of examples that are illustrative of how they work in a topical sense for this year. The structure of the criminal justice system is divided into the federal and state courts. And of both of those court systems that are kind of roughly analogous to one another, there are 3 levels. The first, earliest, and the part of the criminal justice system that everyone is the most familiar with is the trial level, which consists of trial courts. Trial courts are usually the only courts in the justice system that hear novel evidence, which means that when they are deciding whether or not a person is guilty or innocent, they typically have juries, and those juries are allowed to hear novel evidence that is presented by the prosecution and the defense. Defendants in trial courts have a constitutional right to a jury, and because of the recent Ramos v. Louisiana Supreme Court ruling, those juries must issue unanimous rulings in order to convict someone of a crime. Before Ramos v. Louisiana, actually 49 states required unanimous jury rulings, and Louisiana was the one holdout. Ramos was convicted on, I believe, a 7-2 jury decision, and that was overturned by the Supreme Court. The next level of the judicial system is the appellate level, or the appellate courts. Those convicted of crimes at the trial level have a presumed right of appeal, which is a right to have a higher court review the conviction that a lower court via a jury has issued. Appeals are almost always regarding process concerns. So if someone believes that their case was unfairly decided because a piece of evidence should not have been admitted, or because the judge had a bias, or the jury had a bias, or there was, some other procedural problem that occurred during the court case, a higher court can review it. And if the defendant wins their appeal, that higher court or appellate court can overturn the previous conviction. Unlike in trial courts, these are not done by juries, and they typically don't hear novel evidence. Although sometimes appellate courts, especially recently with the advent of things like DNA evidence, have been pushed more and more to consider new evidence in terms of exonerating past wrongful convictions. Sometimes, though, the appellate level will review cases on substantive issues, and that is often because there's a constitutional issue where the defendant or someone who is convicted of a crime argues that the grounds or the criminal statute that they were convicted on is unconstitutional. A classic example that you will experience a lot on this topic is based in the Lopez v. United States Supreme Court decision, where Lopez was convicted of having a gun within a gun-free school zone, which was established by the Gun-Free School Zones Act, which was a federal law that regulated how close to a school one could get while possessing a firearm. And Lopez argued that that was not a constitutional law, that the federal government had no constitutional authority on which to base that criminal statute, and won. And that Supreme Court decision has shaped a lot of how subsequent courts have thought about the authority of the federal government in the area of setting criminal statute and making criminal code. Because the Supreme Court, or the Congress, when it made that law, based it on its interstate commerce power, something that we'll talk about in a little bit, which is an expansive interpretation of what that part of the Constitution allows the Congress to do. Interestingly enough, there's actually no formally Supreme Court recognized right to appeal in the United States. And there's also actually no explicit reference to a right of appeal in the Constitution. Many have argued that this should change, that the Supreme Court should explicitly reference a right to appeal in a decision, and thus codify that legal right for everyone in the United States. But it's almost unanimous the legal system is almost unanimous in its presumption of a right to appeal, and that's based on several amendments, the 4th, 5th, and 14th Amendments, for example, and also the Supreme Court case Frank v. Magnum, which overturned a conviction on the basis of mob domination as a violation of due process. That Supreme Court decision said essentially that if a initial trial decision is obviously rigged and biased, that the defendant has a right to have that decision overturned, which created a presumptive right to appeal that is referenced in current decisions and cases. After the appellate level, there's the Supreme Court level, and all the states have their own Supreme Courts, and then there's also the Supreme Court of the United States. These courts, unlike appellate courts, there's no right to Supreme Court review in the United States, presumptive or otherwise. Supreme courts can choose which cases to review. For example, the Supreme Court grants writs of certiorari according to what's called the Rule of 4. So a writ of certiorari is essentially the Supreme Court taking up a case that has been proposed by a defendant or a defendant's lawyer after going through the appellate courts. And the Rule of 4 is the doctrine that 4 of the Supreme Court justices, there are 9, have to think that deciding that court at the Supreme Court level would be important enough for them to take it up, and then they do. And so the Supreme Court decides 70 to 80-ish cases a year after granting writs of certiorari. The Supreme Court can also grant writs of mandamus or prohibition, which compel inferior public actors like lower courts, justices, or any public official to stop a course of action or to have to take a course of action. Okay. Speaking of the federal courts and federal crimes, there are a lot fewer federal crimes than there are at the state level, and they usually carry much harsher penalties. And we'll talk more about why those things have harsher penalties when we get to sentencing. But just as an overview, the fact that federal sentences are normally harsher is usually used as leverage in state plea bargaining. And this is one interesting dynamic on this topic that will potentially be an affirmative or negative argument, which is that state prosecutors have the option to recommend federal indictment, and they often threaten recommending federal indictment if the defendant does not accept a plea deal. So defendants might be facing a jail term of 5 to 10 years if they take a plea bargain, where at the state level, whereas if the federal government were to indict them, they could face 30 to 40 years. And so a lot of times people who are innocent of crimes will take state level plea deals because the risk that they're convicted at the federal level is just too severe. There are roughly 2 categories of federal crimes, which will inform the 2 basic areas where if you want to write an affirmative that is solely about federal crimes, you can draw from. The first is more obvious. Those that affect the federal government are federal crimes. Crimes that occur in federal territory are an example of crimes that affect the federal government. International crimes, so crimes that are committed against the United States. Targeting of federal officials, so assassinating a federal official is a federal crime. Also, interestingly enough, assassinating or targeting a police officer's spouse is a federal crime too. So if you were to attack a police officer or a member of a police officer's family, you could also be indicted on a federal charge. Election interference is another example, etc. For more on that, there's a really fun article, well, not fun, it's kind of morbid, called 10 Ways Murder Becomes a Federal Crime. And you can learn all the different ways that killing a person, which would normally be prosecuted at the state level, could become a federal charge. And when murder becomes a federal charge, the penalties are substantially more severe, up to and including the death penalty. The other way a crime could be federal and prosecuted at the federal level is crimes that affect or potentially affect multiple states. And this is because the federal government has exclusive authority to regulate interstate commerce. And interstate commerce is a clause in the Constitution that gives the federal government authority over the states on that issue. And that makes sense, because if states were able to regulate interstate commerce, they would be potentially regulating their own interactions with other states, which would violate the principle that states are equal sovereign powers with respect to each other. So there are several crimes that potentially affect interstate commerce, some more obvious than others. A lot of financial crimes are interstate commerce. Insider trading can affect multiple states because people on the stock market trade and own companies all across the country. Murder for hire is considered an interstate crime. Same with bank robbery, trafficking, kidnapping, etc. In addition, and this was the subject of the Lopez v. United States court decision, bringing a handgun within a school or within certain proximity of a school was also considered a crime affecting interstate commerce. And the justification for this was quite extensive. The Congress argued in court that because bringing guns close to schools can make schools unsafe, then those kids will get a worse education or even move schools. And if kids get a worse education in a certain area, or they leave a certain area to go to another school, that potentially that state and that location within the state will have worse economic prospects, and the kids will have worse job prospects, which could affect interstate commerce. And the Supreme Court recognized and ruled that that was an overly expansive interpretation of what Congress was allowed to do in deciding what crimes affect interstate commerce. So if the basis for federal crimes is narrow and can be struck down, what is the basis or the legal justification for federal restrictions on state criminal procedure and state substance? The answer is that it's a lot of the amendments that relate to criminal procedure and due process. For example, Section 1 of the 14th Amendment explicitly provides individuals with protection from state governments, which was the first time in the Constitution that there was any protection from state-level governments at all. And it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So the 14th Amendment has a due process clause, and it has an equal protection clause, and it applies those to the deprivation of liberty, which means that if in order for a state government to put someone in jail, they have to give that person due process in determining that conviction, and every person who is subject to that conviction has to be treated equally. And that, for the first time, allowed the federal government to set much broader restrictions on what the state governments do in their criminal justice systems. And therefore, Congress can pass statutes that enforce the 4th, 5th, 6th, and 14th Amendments by directly changing state criminal justice, or, and this is through a different mechanism, they can indirectly change the state criminal justice systems via the spending clause of Article 1. And in that case, Congress has spending power and can offer states financial incentives via funding programs, or even withholding funding for various things that states want in exchange for states adopting various criminal justice statutes or procedure. So in this way, federal changes to state-level criminal justice procedure, remember we've been talking about procedural versus substantive reforms, federal changes to state procedure are often justified legally based on the Constitution, that the state level procedure that the federal government is changing is insufficiently compliant with one of the various due process clauses or equal protection clauses. And federal changes to state level substantive criminal justice issues is often justified under the interstate commerce clause, which allows the federal government to decide certain crimes affect interstate commerce. There are a few other more arcane justifications for a few different criminal justice actions of the federal government, whether it be in the policing area or in the forensic science area, that are based on many different laws that give Congress and constitutional clauses that give Congress various powers, that we don't have time to go into all of them. But it's always important when you're thinking about debating an app or writing an app or thinking about what negative strategy you think is the best, to ask what the legal justification is for the change that the app is making, because that can inform whether various counterplans are good or whether DAs with legal spillover arguments apply, etc. So that is the end of the first section, which is about criminal justice, the criminal justice system broadly, especially at the federal level. I'm going to pop into the Q&A really quick to answer a few of these if I can, and then I'm going to move on to section 2, which is sentencing. First person asked, where do the recordings go? We'll figure that out later. Is the grand jury part of the trial level? Yes. So the grand jury is often used in order to issue various indictments that require grand juries. So an example of this is first-degree murder in various states is the most serious murder charge. Well, in all states, it's the most serious murder charge. In many states, in order to secure a first-degree murder charge, a grand jury is required in order to issue the indictment. This is significant because normally, in order to issue an indictment, the bar is much lower. Prosecutors just present kind of an initial amount of evidence, and then a jury is required to make the conviction. Here, a jury is required even to charge the person formally with a crime because the crime is so serious. If you've been following the George Floyd case very seriously, you'll know that there was a lot of kind of debate and controversy over whether or not the police officer who killed George Floyd should have been charged with first-degree murder. And one of the main reasons why that was difficult was because in Minnesota, in order to charge a person with first-degree murder, a grand jury indictment is required, which takes a long time, and grand jury proceedings have to be sealed, which is especially difficult in such a politically charged environment. Okay. What's the name of the non-certiorari writ that SCOTUS can give? That is the writ of mandamus, which is basically a prohibitive writ, which allows the Supreme Court to prevent a lower public actor from taking an action or require them make an action. International crime, is that still considered topical if the resolution says in the United States? International crime is normally not considered part of the criminal justice system, so it would have topicality problems even if it weren't for that. However, in the United States might pose an issue for international crime. And so kind of figuring out whether in the United States requires the crime to have been committed in the United States or only the prosecution occurs in the United States will determine that. My personal opinion is that in the United States is normally not a great topicality limiter. And since at least some aspect of the criminal justice system will happen in the United States, that might not be the best limiter against international stuff that otherwise would be considered topical. The right to appeal. The right to appeal is not a formally recognized right in the United States, but it's a presumptive one, which allows people who've been convicted of crimes to have their convictions reviewed by an appellate court, which is at a higher level than the trial court level. There are various different kind of readings of the Constitution in previous court cases that have roughly established the right of appeal for individuals who've been convicted of crimes, but it's essentially, it allows your case to be reviewed by a higher court to ensure that there was not a procedural or a constitutional violation that occurred. Tort law is an aspect of civil law, so not criminal. torts refer to the standards that are the standards or the components of actions that individuals take that harm others. So for an example, there's torts for liability, there's torts for slander and libel, there's torts for contract violation, and they establish when people are responsible for harm to others that can be redressed via civil procedure. Okay, so I'm going to pause answering questions there because I want to get to all three areas, but I will come back to all of these and answer more after the end. Okay, sentencing. Sentencing is the stage of the criminal justice process wherein someone convicted of a crime receives criminal sanctions in accordance with the law. That, in case you see the card later, is from an author named Stobbs, who is defining sentencing in relation to many other aspects of the criminal justice system. How sentences are assigned to various crimes reflects the broader concept of different theories of justice. And these are ideas of what constitutes a just response to a violation of the law or a harm against another. There are several relevant theories of justice that have, over time, informed our criminal justice system's response to crime, and I want to briefly summarize kind of the main four. The first is retribution, which states that the point of criminal justice is to punish those that commit crimes. Retribution, as a theory of justice, believes that punishment for crimes is an end in and of itself, that similar to an eye for an eye, that if you commit a crime, you have justified punishment done against you. You've sacrificed the liberty that you were previously accorded as a citizen, and you have to be punished for crime. There's other kind of broader reasons why retribution is sometimes supported, that retribution is a social release mechanism, that if people were allowed to commit crimes unpunished, that society would just break down, and that it's good for society to be able to, you know, get all of its frustration with crimes being committed out in the form of retribution. Yeah, so punishment is good, is retribution. The next is, well, and also that individuals who commit crimes are not safe to have in society and thus must be removed. The second theory of justice is deterrence, which is very similar to retribution, but has a little bit more of a community or a social-based angle, which is that sentences should be harsh enough such that they incentivize others to not commit the same crime. Individuals, this in a deterrence-based theory of justice, individuals may actually face harsher penalties than they maybe deserve, so that society as a whole experiences less crime. So you will see kind of the deterrence theory of justice when judges say, I'm going to make an example of you, for example, and give someone 30 to 50 for cocaine possession. That is a deterrence model, which, while the punishment is not directly proportional to the crime that was committed, it's designed in order to minimize the overall amount of crime in a society. The third theory of justice is rehabilitation, which views sentences and the criminal justice system as a whole as responsible for reforming the behaviors of those that commit crimes. In this theory, the system has a responsibility to the victim and the broader community, so to, take people who commit crimes off the street, but also has a responsibility to those that are convicted of crimes, that the system has a responsibility to help them transition from someone who commits crimes to someone who does not commit crimes. The fourth theory of justice that underlies the criminal justice system is the restorative justice theory, which views crime as both a product and a cause of communal harm that should be rectified as a community. This resists placing blame for crimes solely on those that commit them. And sentences here take wildly different forms, often not directly punishing people for nonviolent crimes like theft, because restorative justice sees theft as more an example of a socioeconomic injustice in the society than an individual's propensity to break the law. And so restorative justice takes a much more flexible approach to remediating harm than do the other three. Okay. Sentencing happens on a procedural note as a separate trial from one that establishes conviction. So who decides the sentence depends a bit on what the conviction is. And the reason is that for the death penalty or capital punishment, a jury is often required. It is always required to give someone the death penalty at the federal level, and it is required in most states as well. For basically everything else, judges are the ones that set sentences, but there's a lot of things that influence the judge's ability to set the sentence. For example, prosecutors, despite not having any formal control over sentencing, wield enormous influence because they can recommend sentences. And there's a pretty strong tradition, especially in various states, where judges will follow or at least take into consideration prosecutorial recommendations for a sentence. It is important to note that sentencing is not always jail or prison, even under retributive or deterrent theories of justice. Probation, house arrest, mediation, drug treatment, mental health treatment, community service, the death penalty are all examples of non-jail or prison sentences that a person can be assigned by a judge. Things are a little unique in sentencing at the federal level, largely as a result of the guidelines movement, which originated in the SRA, or the Sentencing Reform Act of 1984. And this is going to be an inroad into introducing some of the AF arguments that will be read on this topic. The SRA abolished federal parole. So if you're convicted of a federal crime, not only are your sentences much harsher, you have to serve the whole thing. And you can only not serve your whole sentence if it is commuted. And the SRA also established the United States Sentencing Commission, or the USSC. This shifted kind of the milieu of federal sentencing from rehabilitation, which was the norm prior to the 1980s, or at least a strong current, to what a prominent legal scholar, Nancy Gardner, calls limited retribution, which was a lot more palatable to the public and to the Congress. It wasn't immediately apparent at the time whether this would be an advisory system where the USSC recommended sentences that judges could take into consideration, or a mandatory system where judges would have to adopt the sentencing recommendations that the USSC propagated. This system quickly, as many of you probably know, became mandatory, hence the creation of mandatory minimums based on the federal sentencing grid. The federal sentencing grid is a system where the severity of an offense multiplied by previous convictions determines the score of a person's conviction, which is translated into a sentence, and rigid. For what it's worth, mandatory minimums in this sentencing system are almost universally reviled by criminal justice scholars because it's inflexible, often racially distributed because of the propensity for certain minorities to be more likely convicted or to have minor prior convictions, and is harsh in its belief that people really cannot be rehabilitated. This was largely the end of discretionary sentencing because there was a convergence between the right and the left around this time on the need to set minimums, that the left thought that individual judges should not be trusted with sentencing decisions because they are racist or biased, and the right believed in being tough on crime and taking the decision out of judges' hands, and hence as the end of discretionary sentencing came about. Possible changes to sentencing also follow the same procedural and substantive scheme, which I will use to introduce two AFs that were going to be discussed at the DDI this year. The first, so in procedural reforms to sentencing, it's changes to the way sentences are assigned. So an example is the Drug Courts AF, which has the following plan text. The United States federal government should create an accreditation program for drug court expansion that requires universal screening, objective metrics for admission, and tiered evidence based on treatment programs. Drug courts, if you're not familiar, hopefully, are specialized courts that provide an alternative to traditional sentencing, offering treatment and supervision instead of direct punitive sentences. So they're a more rehabilitative, remember our theories of justice, approach to drug crimes than are direct criminal sentencing and prison time. And this is a procedural reform because it universalizes and makes more objective the ability for people to get diverted into a drug court versus having to stay in the normal criminal court system. Another example is the evidence-based sentencing, or EBS affirmative, which has the following plain text. The United States federal government should require that risk assessments used at sentencing employ algorithmic affirmative action to correct any isolatable racial bias in algorithmic outputs, because doing so is required by the Equal Protection Clause. So there's a lot happening here, some of which we've already talked about. For example, justifying this change based on the Equal Protection Clause underscores the legal basis that the federal government has to make this change. But requiring risk assessments be used at sentencing changes how risk assessment happens. Risk assessment in sentencing is normally the consideration that judges make about the risk to society that a convicted criminal poses. And usually it's in terms of recidivism, or the likely to commit another crime in the future. And sentencing is designed, risk assessments at sentencing are designed to reduce recidivism, to reduce the likelihood that someone will commit another crime. These risk assessments have taken an algorithmic turn, which take into account various different factors: previous convictions, income, zip code, jobs, and use a mathematical model to predict whether someone commits another crime. The problem with that is that a lot of these proxies, income, zip code, job, previous convictions, are racially motivated, or may even be motivated by other protected categories, and thus potentially violate equal protection, or will predict more recidivism in people of color or minorities than white people. There's also the question of whether or not these will even hold up in court at all. They're called proxies for race, so things like income and zip code, well, not explicitly someone's race, are highly correlated with it, and therefore can become proxies for being a protected minority. And this act requires race be used explicitly in order to correct for other types of algorithmic discrimination in sentencing risk assessment. There are also substantive reforms to sentencing, so change sentences for a specific offense, i.e. adding a mandatory minimum or removing a mandatory minimum. No one thinks mandatory minimums are good, as I've kind of already described in the literature. You can also eliminate a sentence altogether, for example, eliminating the death penalty. I'm going to move straight on now to the third section with policing, just so that I can get through that and forensic science, and then we're going to talk, and then I'll take questions at the end. The largest thing that will determine the policing area this year is what that term means. There are two schools of thought on what constitutes policing: social regulation of social order, so a really broad interpretation that sees policing as keeping the peace at all, versus work done by police officers, which are specialized people whose primary responsibility is use of legitimate force to safeguard security, which is a narrow definition. And both of these are compared by Platts Fowler, another topicality author you will see. Relevant constitutional amendments that constrain police activities are 4, 5, 6, and 14, roughly. The Fourth Amendment protects against unlawful searches and seizures, so means that police can't show up at your house without a warrant and inspect your belongings. The Fifth Amendment ensures due process and a right to an attorney, and also a right against self-incrimination. So you have the right to remain silent is based in the 15th Amendment. The Sixth Amendment, or the Fifth Amendment, not 15th. The Sixth Amendment is the right against police interrogation without an attorney. So police can't indefinitely hold you and ask you questions without having a lawyer present because of the Sixth Amendment. The Sixth Amendment also means that you can face your accuser in court, but that's not super relevant to this topic. The 14th Amendment is the one we've already talked about: due process and equal protection under the law, especially as it relates to state governments. On the other hand, police are also protected, and they're protected under what's called qualified immunity, which is the legal doctrine that says that public servants, and in this case police officers, are protected from civil suits, so civil, not criminal, unless the official violated clearly established statutory or constitutional rights of which a reasonable person would have known. Qualified immunity originated in Pearson v. Ray, that's another Supreme Court decision. But the modern test, so that by legal test, we mean like certain elements that are required, namely clearly established rights, which a reasonable person would have known. The test for that was established in Harlow v. Fitzgerald. And as it relates to kind of the common modern controversies, removal of qualified immunity is considered a necessary step in police reform by many activists in the wake of police brutality and killings. Many proposed changes to policing in the United States, there are many. use of force, like eliminating chokeholds, deadly weapons, rubber bullets, stopping searches and seizures, or reforming them, like stop and frisk, car and body cavity searches, no-knock warrants, like the one that was used when Breonna Taylor was killed, civil and criminal asset forfeiture reform, changes to surveillance, depending on how you define policing, etc. The last aspect or area of the topic is forensic science. There are two broad types of forensic evidence, and they're divided roughly by the ability to reliably obtain them at a crime scene for an indefinite amount of time. So that leads us to two categories. First is fragile or transient evidence, which you're not able to reliably obtain at a crime scene for an indefinite amount of time. This includes anything biological, hair, bodily fluid, skin cells, glass, fractured objects, impressions like shoes, tires, barefoots, and fingerprints, point of fire origin, so in an arson case, figuring out where a fire started and if it was intentional, gunshot residues and patterns are all fragile or transient evidence. The opposite of that is solid or tangible evidence, things that can be reliably obtained from a crime scene indefinitely. Tool marks, weapons, bullets, cartridge cases, unfired cartridges, drugs and drug paraphernalia, documents and computers and devices, etc. The question is, where does that leave us in the 21st century, where we have a growing number of crimes and criminal law related to digital and cyber evidence? The consensus is that these are fragile, so the first category. Digital evidence cannot be reliably obtained upon securing a crime scene, partly because what is a crime scene is now in flux and entirely difficult. But even if there is, data can be remotely or automatically changed or deleted, and access may depend on physical choke points, such as servers that can be destroyed remotely. Digital evidence has also expanded the fragile category into 4 new subcategories: transient data, which is lost upon shutdown of a device; timely fragile data, which is stored on hard disks but can easily be altered; temporarily accessible data, which is data stored on a hard disk for a temporary amount of time; and live data, which is data, real-time digital evidence, often gathered in a surveillance or a digital stakeout operation, where online activity of one person is being monitored by another. So what can AFS do in the forensic science area? Again, we can divide this into procedural and substantive reforms. Procedural forensic science reforms often change evidence admissibility standards and requirements, or requirements for forensic investigation. This category is broader than it may seem, because admissibility of evidence in a court case is actually the primary way that procedural rules for evidence collection are enforced. So, for example, DNA evidence, a prohibition or a removal of DNA evidence would be enforced by making DNA evidence not admissible in a court decision. Another procedural forensic science reform is jury and judge education that may increase education of judges and juries on what is the standard for forensic science, because that stuff is often so technical, especially in the biological sciences and in the digital forensics areas, such that people being convicted of crimes is often reliant on juries having intense technical knowledge that they don't really have about those areas. Last, the one thing I'll say about the forensic science area is that it's different than policing and sentencing in that it has the most direct potential for increasing police and prosecutorial ability, and that increasing standards for forensic science can often make forensic science better. And thus, unlike sentences and policing, where you would have to directly make a policy that strengthened those various aspects, forensic science can indirectly strengthen this, the scope of the criminal justice system, just as a product of it improving the tools of those that use them. So that is the end of the third area. With that, I will answer as many questions as I can get through in the next 9 minutes. Okay, what is an indictment? An indictment is when a person is formally charged with a crime. An indictment precedes a conviction. Yeah, so a charge. Can you repeat the part about interstate commerce clause versus the Constitution and Congress influencing laws on states? Yes. So interstate commerce clause is also in the Constitution. So this is all constitutional, but it relates to what authority Congress has in order to set law, criminal code, and to suspend a person's liberty. So there's no direct place in the Constitution that allows the federal government to lock someone up. And so there's various aspects of the Constitution that have to be used. The Interstate Commerce Clause says that Congress has the authority to regulate activities that affect interstate commerce. So if a crime were to affect interstate commerce, Congress would have the authority to regulate it. So a really obvious example is insider trading, because insider trading affects many states at once, because companies that are being publicly traded on the stock market often have locations in various states. They are, the stock market itself is inherently national, and thus Congress has the most direct authority to regulate that. Same with kidnapping or anything that crosses state lines, thus automatically becomes an interstate issue. I think the Constitution part of your question is about those other amendments that I was talking about, 4, 5, 6, and 14, which are more about criminal procedure and regulate, and under which the federal government has authority to regulate state criminal procedure. Because if states enact a criminal code that says criminalizes free speech, so if a state enacted a sedition law that said you couldn't say something critical of the government, the federal government could intervene and stop that law on the grounds that that violates a person's First Amendment rights. So the Bill of Rights and a few other amendments do provide some basis for the federal government being able to challenge state laws. What is an example of a federal change to state procedure? The EBS Act is a good example because it says that not using algorithmic affirmative action in risk assessment violates the Equal Protection Clause because of disparate racial outcomes. And thus, that amendment could be enforced on states, because if they were using algorithms in a racially disparate way, that would be a violation of the 14th Amendment, which every individual has a protection against the state governments from disparate harm. Next question, wouldn't procedural changes inevitably be tied to substantive change as well? For example, if you wanted to decrease racial profiling across the police, wouldn't you need substantive change that decreases the amount of economic incentives the federal government gives to police or change the way they carry out their discretion? Yes and no. Some changes do require both procedure and substance. So if you wanted to say stop police brutality, there's no way you could do that just procedurally or just substantively. It would be a combination of both. However, there's some procedural changes that are not substantive at all. For example, if a law just changed how long someone could be detained prior to an indictment, then that would not be substantive. It doesn't change any substance of the criminal code. It just changes how long someone who's indicted can be held without a trial, how long habeas corpus can be suspended. Would appeals suspend the decision of court cases? If an appeal is granted, so a higher court decides to take up an appeal, that won't necessarily release a person from jail or reverse their conviction. But if the appellate court agrees and rules in favor of the person who's convicted, that can reverse the previous court decision and end that person's sentence. If the Supreme Court refuses to address a case or appeal, what happens? Nothing. That's the end of it. If the Supreme Court refuses to take up a case, the most recent or the highest court decision on that issue stands. What is Theory 3 called? Theory 3 is called rehabilitative justice, which says that the criminal justice system is designed primarily to help people who've committed crimes not commit them again. And that has a benefit both to that individual person and to the society in which it happens. Can I explain the restorative justice? Yes, restorative justice is a model that sees crime as not only harmful to a community. So when you rob a bank, not only does that harm the community you're in, but it also was prompted by harm in the community. That what motivated you to rob a bank is probably economic injustice, that people live in poverty or there's inequality, and that motivates people to commit crime. So restorative justice views crime as not an individual phenomenon like the other three theories of justice do, and instead sees it as a product of complex social interactions that must be ameliorated at that same complex social level. So just like crime is not committed individual people don't just wake up one day and decide to go steal stuff. We can't punish crime individually. We have to reform society around making that kind of action less likely. And often that involves mediating between disputes. So if some person hurts another person, it oftentimes having those two people involved in whatever dispute resolution ends up being used in lieu of just putting a person in jail. Can you counterplan out of mandatory minimums with a counterplan to commute sentences? Yes. Is the topic bidirectional? I believe it is. I don't believe the word reform means you have to make the system nicer. I think that forensic science is a great example of a place that's inherently bidirectional, because what does it mean to make forensic science less mass incarcerating or less violent? It's, requiring remaining standards for various types of forensic evidence doesn't lend itself immediately to the view of reform as just making a system less racist or less violent. And so I do believe that it is topical to expand the power and even the retributive nature of the criminal justice system. Are drug courts an example of a sentencing alternative? If so, would alternatives to prison like drug courts fall under sentence alternative and thus be topical? Yes. I believe the drug court staff is topical under, it's an alternative to sentencing, that mandatory treatment programs are an alternative sentence to putting someone in jail. Since most policing takes place at the local level with noticeable exceptions like ICE, what would a topical policing act look like that could reasonably avoid states' counterplan? If the federal government, well, some policing takes place at the federal level. There are federal police forces in terms of topicality debate ensues about, for example, federal surveillance officials or the FBI that do conduct some policey investigations and have legitimate use of force at the federal level. Second, there's also DC police, things like that. A topical policing act could regulate state level policing, though, via the same amendments that I've been talking about, that if a state or local police practice was found to violate equal protection, a prohibition against cruel and unusual punishment, First Amendment rights, that the federal government would have constitutional basis to prevent that from happening. How they will answer the state's counterplan depends on what their answers are to their specific area. If there is a federal law that prohibits states making changes to those various things, for example, maybe federal action will be necessary. The 4 categories for digital evidence are transient data, timely fragile data, temporarily accessible data, and live data. And you can look all of those up. I'm also going to give all your lab leaders a copy of this lecture, so they will have that and links to all these things, so you could look those up and ask them. What is qualified immunity? It is immunity of public officials acting under the law to be immune from civil cases. And remember, there was kind of a test for that, which is that there has to be a clearly identified statutory or constitutional right that is being violated that a reasonable person would know about. That's the most recent Supreme Court test for qualified immunity. The opposite of fragile evidence is, I want to get the exact term right, it is solid or tangible evidence. So things that can be reliably obtained at a crime scene for an indefinite amount of time. We're technically 1 minute past, but I'll answer one more. What is the relative importance of risk assessments and sentencing guidelines if prosecutors can also have strong influence? It's complicated, but if prosecutors don't decide sentences on their own, and so there's good reason that if risk assessments were changed, that judges could also, use risk assessments rather than exclusively relying on prosecutorial recommendations. In addition, if like the EBS Act does, if it requires that algorithms use a very specific test in order for racial disparity, then that would presumably override whatever the prosecutor was recommending, because that would be now a constitutional or Supreme Court mandated requirement for how sentencing should be conducted. Okay, I'm going to go to ones that were asked most recently. Has there ever been attempts to move digital evidence to tangible evidence? Perhaps, but remember that the reason digital evidence is considered fragile is because of its inherent nature, that it's of the evidence, that it's just difficult to keep track of and to have consistently. And thus, it's not so much a legal characterization of it as fragile evidence, but a technical one that kind of requires us to treat it that way. Do laws for policing differ for groups like campus police, private police, or private investigations? Yes. So first, if a private police officer or one who is not employed by the government commits any offense, they are not protected under qualified immunity. So if you're not a public official, you're not protected under qualified immunity if you're a private police officer or security guard or whatever. If a mall cop like kicks you in the shin for no reason, you can sue them and the mall. Like there is no reason why that person is protected under qualified immunity protections. In addition, the various jurisdictions have different regulations. So maybe public universities technically are, the police officers who work for them are public officials and therefore are compliant with a slew of state and federal laws, but are also compliant with whatever individual municipal laws are established for them as well. And that applies kind of to all city police departments or county police departments. In addition, anyone who does anything related to the use of force must be compliant with the Constitution. There's no one in the United States who can violate the Constitution as it relates to American citizens' rights against their government. So that's kind of a broad prescription across any jurisdiction. There's no one in the United States who can suspend habeas corpus. There's no one in the United States who can force you to testify against yourself, etc. Okay, I think that's all the time we have. I will try to find a way to copy these questions to send them out, or maybe answer some of them later. And I'll also send a copy of the lecture notes with all URLs and things like that. So hopefully maybe your lab leaders, if you ask them, can help you track down some of the concepts you're still confused about.